A mistake from the past can continue to affect someone's future long after a case is over. A criminal record can impact employment, housing, education, and more. But for some individuals, there may be an opportunity to move forward. Today on The Domino Effect, we're joined by attorney Blaine McChesney to discuss sealing and expungement, who may qualify, and how clearing a record can open new doors. I'm your host, Charlene Stanford Green, and this is The Domino Effect, where community issues meet the systems that shape them. Many people don't realize that an arrest or criminal record can continue to create challenges long after a case has ended. Joining us today is attorney Blaine McChesney to help us understand what sealing and expungement are, who may qualify, and why they can make such a huge difference. Attorney McChesney, thank you so much for being with us today.
Thank you for having me.
I'm so excited to speak about this topic. Now, I know you are a criminal defense attorney for over 25 years, so you have a wealth of experience and a lot of knowledge when it comes to defending folks. I want to speak to you today about sealing and expungement. Many of us may have heard of those terms, but can you explain to our audience what they are and what they mean?
Well, after a criminal prosecution is over, no matter the result, that doesn't really end there. There's a secondary process to try and get that off of your record called sealing or expunging it off of your record. That process of sealing just puts a court seal over it so nobody can see it without the court's permission. Expunging just means the file's virtually destroyed. There's always a copy kept at the Florida Department of Law Enforcement, but people can't see it. Now, for purposes of just the general population, sealing and expunction has very little difference to them because it's taking it off of your background searches that companies would use to hire you. You can lawfully deny it exists with either one. So it doesn't really matter as much to an individual as it would, the court process. So if it's sealed, you can do a court order to unseal it, get stuff back out of it. If it's expunged, though, it's very difficult to get those items back later. So if you want something out of that file, the file's gone, and it's just a little copy at the Florida Department of Law Enforcement. It becomes a little harder to get a hold of those documents.
Okay, so if someone is looking to have their record sealed or expunged, what advice do you give them to consider which route to take?
Well, you're only eligible usually for one or the other. So how it works is if your case got completely dismissed, you can usually expunge it. But if you wind up pleading to the case, like getting a withhold of adjudication, that withhold of adjudication, which means, and adjudication of guilt means a conviction on the case. Withholding adjudication means not adjudicating. Withholding that means I'm not going to do it. So they're not convicted. Now, they might have pled, they might have gotten probation, they might have had to do some community service, but as long as it's a withhold of adjudication, you can seal it. If it was dismissed, you can expunge it. You can also expunge a case that's been under seal for 10 years. Now, why you'd want to do that process, I'm not quite sure, because again, for the individual, it doesn't really make a difference.
Okay, and if someone is looking to apply for a job, you mentioned when they're filling out a background check or application, some of the questions are asking, have you ever been arrested or convicted? How does that work if your record is eligible?
That's a great question. So it really depends. There are some exceptions. As anything in the law, there's always exceptions.
Always exceptions, yes.
But in general, once it's under seal or expunged, you can lawfully deny it exists on job applications. Again, there are exceptions to that. So obviously, if you're applying for a job with the federal government and you require a security clearance of some kind, or a state level where you require a security clearance, they're going to be able to ask you about sealed and expunged records, and you're not going to be able to deny it exists. Same thing for anything that involves medical, where it's direct access to patients, or so nurses, doctors, that kind of thing.
Or maybe working with children.
And DCF, right? Anything working with children. So those are the three big categories of exceptions where even if you've sealed it and expunged it, or either or, you're going to have to explain that to those employers. But for the 98% of employers, you can deny it exists.
Okay. Now, who can qualify to even explore either of these options?
The main thing I see in my practice that would be a disqualifier, and it's a big one, is if you've been convicted of any crimes at any time in your life. And convicted meaning adjudication of guilt. So you can have 10 cases where the court withheld adjudication, which is a non-conviction, and you can seal or expunge one of them. But if you have just one conviction on your record, you're denied eligibility. So again, there are always exceptions to that. If you're a victim of human trafficking, there's little exceptions written into that.
Okay.
But for the most part, if you have a conviction on your record, you're not going to be able to use the statute to seal or expunge anything else off. Now, this means that you could have gotten adjudicated guilty in Alabama 20 years ago for driving with a suspended license. That's going to disqualify you for sealing and expunging here in Florida, unfortunately.
Oh, wow.
And that's the biggest disqualifier. I see people all the time that, well, I don't have anything on my record. And I have to dig a little deeper. And I'm like, okay, you're 50 years old. So when you were 18, maybe, where
Did
else did you
anything
live?
happen when you were younger? Or like you said, if something occurred in a different state,
Yes.
and they might be thinking, well, I haven't done anything in the state of Florida, and this is where I've lived for the past 20 years.
Correct.
So then you have to do some more digging.
Correct. And even juvenile records, if you were adjudicated delinquent for certain offenses, that can disqualify you
Oh
from
my gosh.
sealing or expunging records as an adult. So you have to dig back all the way to juvenile history to make sure this is someone who's going to be eligible. And you don't want to waste money with applications and fees and attorney's fees if you're not going to be eligible.
And then are you able to help folks identify that before they even go down that path, or you try your best to do so?
Yes, well, in-depth questioning, number one,
Yes.
right, is let's
Tell me
dig back.
everything.
Right, and think back. Have you ever lived anywhere else, even when you were a child? And a lot of people think traffic offenses, well, those weren't criminal. There are criminal traffic offenses like driving under the influence, leaving the scene, reckless driving, that you got a ticket for, but it's a crime. Driving with a suspended license is a huge one. People get their license suspended. They get caught driving with a suspended license. It's a crime in most states. It's a crime in Florida. And they wound up with an adjudication because they just wanted to get fine and court costs and not do anything with it. And that was 25 years ago. And it doesn't matter. You're not eligible if you got that conviction.
So once the conviction is there, regardless of how far back in time it may have occurred, it makes you ineligible.
Correct. And I also tell people this when I represent them on the underlying crime, and that the charges are dismissed or we got a withhold of adjudication. And I tell them, look, you're eligible to seal or expunge this, but if a year from now, 10 years from now, you get a adjudication of guilt on a crime, you can't go back and now seal or expunge this because now you have a conviction. So it's before or after the offense you want to seal or expunge. No adjudications, no convictions.
Oh my goodness. So there's a lot of special circumstances surrounding this.
Yes.
And you mentioned also in the state of Florida, you can only qualify to seal or expunge one record?
Yes, so it's not like a bankruptcy. People think, oh, I can just, expunge my whole record and start clean.
Right.
And I don't think bankruptcy is like that anymore, actually. But for the most part, yes. If you have 10 cases where they were all dismissed, you can pick one of them, but you can't seal or expunge all 10.
Okay.
And that becomes problematic too when you have multiple things that have happened to you, even if they were all dismissed or you got 10 withholds of adjudication. You have to pick one and just one.
Okay, and how do you help someone choose which one is best to select?
Right, so that's not really a legal decision, but I always look at it as what would employers think of this, right?
What are they maybe looking for?
Right, I mean, obviously any kind of indications of violence, and I go, you probably want to pick that one because even if it's a misdemeanor domestic violence, that shows a character flaw that maybe employers would be really trying to deal with differently than say you have a possession of marijuana. So I look at it that way. Felonies versus misdemeanors, you usually want to pick the felony, but otherwise any crimes of dishonesty, theft, false
Forgery.
ID, forgery, right? You want to get rid of those. Again, just kind of looking at it as if I'm Walmart and I'm hiring somebody and I see a possession of cannabis or I see a petty theft, which one is going to give the employer more pause? I would think that the petty theft, because it's a crime of dishonesty.
Okay, and what is some misconceptions people may have about even going either route?
Well, versus sealing versus expunction?
Yes.
Well, again, I think they think it wipes everything off, and it doesn't. And they also, I think it's interesting because, and I get this all the time as well, it does not take things off of the internet. Okay.
That part, right, the
Right.
Google search.
Right. The internet is its own beast.
Yes.
So if you seal or expunge the record, what it's doing is it's taking it off of the background searches that employers might use, most of them. But if employers also have a secondary internet search, and some employers are searching your social media now before they
Right.
offer you a job.
Exactly.
And an internet search will still bring it up. Typical is mugshots.com.
Okay.
There was a big lawsuit filed about that with the Attorney General's office, saying it's kind of extortion, but the court held it's freedom of speech, so they're allowed to put that out there.
They have that right.
Yes.
Well,
So
I'm going to go ahead and talk to you more about this when we get back from our break, because this is very interesting and very intriguing. So, a criminal record doesn't always have to define someone's future. When we return, we'll discuss the process of sealing or expunging a record and what people should know before getting started. Stay with us. We'll be right back. Thank you, but no, it's interesting.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty.
Welcome back to the Domino Effect. For many people, understanding the process is the first step toward moving forward. Now, I want to talk to you about what someone will do if they have a record and they want to see if they even qualify to have it sealed or expunged. What do you recommend the first step should be?
Well, an attorney can help you out with that because we can give you some advice about whether you qualify. But like we were talking about earlier, sometimes they've forgotten about things that might have happened 20 years ago. I always recommend they go to the Florida Department of Law Enforcement website, FDLE's website, and they have a sealing expunction little button you can press.
Okay.
And it's not a pre-qualifier, and they even make that representation, but you can do kind of a free, hey, can you do a search on me to see what I have? And it's almost like hey, we'll give you what we can see so that you can determine if this is something that you want to go forward on if you qualify.
Okay.
So that's something
and that's just for the state of Florida, though, right?
Just the state of Florida.
Okay.
They do an extensive background search when you actually do the sealing expunction, and they do all the states, and they do an extensive background search. So I do recommend going there if they're not sure of what their record is. Sometimes if they tell me, well, it was in the state of Georgia and it was 30 years ago, it might be very difficult to locate that in the clerk system. You have to go to the clerk in Georgia to try and locate that offense. And sometimes you just won't know until you've actually done the application, and then they do the research and they come back and say, nope, this was a conviction back in the day.
Wow. Now, if you go to FDLE.com, is there a cost for starting the search?
No, you can get them to do kind of a little pre-thing, free of charge. But like I said, it's a little limited because it's not going to be as extensive as they're going to do when they actually do the big background search on you. But then the process from there is it's a little complicated. It's a lot of paperwork, and you have to be perfect on the paperwork.
If you're not perfect on the paperwork, what happens?
They just send it right back to you and tell you why you weren't perfect and to correct it.
And resubmit.
We resubmit everything. You start the process over again.
Wow.
Yeah.
Now, what happens, Blaine, if an adjudication is withheld or a case is dismissed? Does that automatically mean your record can be sealed or expunged, or do you actually have to do something?
And that's a great question. They did change the Florida statutes a few years back that allows for certain offenses to be automatically sealed or expunged, in this case expunged, if they were dismissed. But not all of them. It has to be a forcible felony or a sex crime. For some reason, it's not just all offenses. When a case is dismissed, the clerk will take it off their website, the public view.
Okay.
But like we talked about, that doesn't do anything to the background searches. It doesn't do anything for internet searches or anything like that.
So when you say the clerk takes it off from public view, so if I go on the clerk of court and I'm doing a search,
yes,
your case may not show up if I do the search.
Yes.
But it still may be showing up if your employer is looking.
Absolutely. So, the case isn't going to be there on the clerk system, but if someone does an internet search, your mugshot's still going to be there. If someone does a background search, like Target or one of these employers does a background search, it's still going to pull up, and that's problematic. So that's why the process of actually getting a sealing expunction from the Florida Department of Law Enforcement is important.
Okay. Now, what if someone does have the mugshot showing up? Are there any websites or resources available for folks to then pursue trying to remove the mugshot or trying to get not as many searches appear on the internet?
And this is called an internet scrubber. And
Okay.
it's not a legal process. There are companies, and don't ask me how, I'm a lawyer. It's magic to me. But they somehow go into all of these websites and figure out how to get all of this stuff taken down in one way or another. And it's called an internet scrubber. There's a bunch of different ones. I wouldn't recommend one over the other, but they can do a research. If you Google internet scrubber because you want something off of the internet, those are the people to go to. But like they said, once it's there, if someone screenshots something, it's in their folder. It's never completely gone.
Correct, not completely. Now, what about the timing, the statute of limitations? Does that apply to these cases when you're trying to see if something's eligible?
Right, so there is no statute of limitations for sealing expunction. So you can seal or expunge something that was 25 years ago or something that just happened yesterday. So there's no real time limitations, but like I said, if you wait, and you might think, well, that little case I have is not a big deal. I'm going to wait and see if anything else happens in the future. And you're convicted of a crime in between, that's what makes you ineligible. So that's the only caveat. Like you can wait 10 years and then do it then. But what you don't want to wait for is that dream job opportunity. And then I get the phone calls, hey, you remember that case you handled for me 3 years ago? Well, I've just got applied to Lockheed Martin and it's this great job and it's going to be fantastic for me.
Right.
But I don't want them to see this. And I'm like, when is your job interview? And it's a week later and well, that's not going to happen.
Okay.
It's a 6-month process.
I was just going to say, how long does it take? What are the steps involved and the costs?
Right. So the process itself is 6 months. If you handle it yourself, then you can just literally pay a $75 application fee to the Florida Department of Law Enforcement, and you pay court costs at the end if you're successful. So the court costs range from $50 to maybe $150 depending on the clerk's office that you're doing this in. So you could do this for as little as a couple $100 if you're very good with paperwork and can
Following directions very, very steadfastly.
Yes, it has to be very meticulous. And some people are very meticulous and can really follow that along. But of course, we use the e-portal system now to file things with clerks of courts. And you also have to learn how to do that and to upload them into the e-portal system as well. So you're uploading documents there. And it does have to be very, very specific. Like, if this document was signed but not notarized, then it's going to be rejected. You have to file an application with the Florida Department of Law Enforcement.
Okay.
It's not bad. It's a page.
Where do you get the application from?
If you go to the Florida Department of Law Enforcement website,
Okay.
that same little tick that I found, you can check that box and go to sealing expunction. They have a frequently asked questions kind of section on that. They have all the forms you're going to need. You can click a button and literally fill it out online and then print it.
Okay.
Now, for some reason, they haven't quite gotten into the upload it to their system automatically. You have to print it out and then sign it in front of a notary and then send it back to them. But there's additional documents from there. So that's the first part, is the application. And you send them all of this as a package. So you're going to do an application. You have to have an affidavit, which complies with the Florida statutes. You have to have a petition that you're going to file to seal or expunge with the court, and that has to comply with Florida statutes. And then there's also a process if you're going to expunge versus just seal. You have to send a document to the state attorney's office called a written certified statement. So the state attorney's office can certify that this is eligible to expunge and not just seal because it was dismissed.
Okay.
Right? So then you have to send that to the state sends that back to you. So now you've got the application in front of you, you've got the affidavit, you've got the petition, and you have the state's written certified statement. So that's a lot. And the biggest part is you have to have your fingerprints rolled again.
Okay. So do you go to the sheriff's office to get your fingerprints done?
Yes. So, and that's a rather big deal too. Like the Orlando Police Department stopped rolling fingerprints for some reason, so certain agencies won't do it, others will. Some require an appointment. Orange County Sheriff's Office could take 2 or 3 weeks to get an appointment to roll your prints. Locally here, in Orlando, UCFPD does these. without an appointment, 2 days of the week.
Okay, so there's some options available.
Sure.
And I imagine there's a cost for that.
Well, you pay the agency $7 to $15 depending on the agency, and they'll roll your prints. But again, little things like, did they sign the fingerprint form? Yes, the person who's fingerprinting them has to have signed it. And if it's not signed, it gets kicked back. So it does have to be very meticulously done. And then that whole package goes to the Florida Department of Law Enforcement. And that's where the fun begins of the background check.
Wow. And then you said that takes about 6 months total.
From start to finish, if I get the case, it takes 6 months to do it because it takes about a month for and this is from the time my client sends me the paperwork back. I mean, obviously.
So that could take a while too.
Yes, I need the paperwork back for me to get started. So from the time I get the paperwork to the time I get the court order is usually about 6 months.
Okay.
Right in there.
Wow.
But the background check Florida Department of Law Enforcement does, that's about 4 months of the process.
So that's a huge part of that time right there.
Yes, and
Okay.
that's why people say, well, can I expedite this because I've got my dream job coming up?
Right.
And I'm like, there's no way to expedite the Florida Department of Law Enforcement. They're going to take it in order that they receive it, chronologically, and they're going to work on that, and it takes about 4 months. It used to take longer. I think they hired some more personnel down there.
So at least it's not as long as it used to be.
It used to be 9 to 12. And so now we're at 6 months, and we have been for the past 4 or 5 years, which is refreshing, but it's still 6 months.
Okay, awesome. Well, when we come back, we're going to talk more about how someone can get help and how you may be able to help them as well. Up next, we'll talk about how clearing a record can create new opportunities and how Legal Aid Society helps eligible individuals in doing so. We'll be right back. Welcome back to the Domino Effect. Life after sealing or expungement can be genuinely transformative for someone trying to move forward, though it helps to understand exactly what changes and what doesn't. So Blaine, let's talk about how someone's life can change and alter after getting a record sealed or expunged.
Well, obviously, the biggest change there is you're going to be applying for jobs, and as long as it's not one of those categories we discussed, they don't have to reveal it anymore on a job application. And that also means that, even if they ask, have you ever been convicted or have you ever been arrested, and those like vague questions like arrest,
Right.
you can still deny that
Okay.
once it's been sealed or expunged.
Because some people may get confused when they ask questions, have you been arrested, have you been convicted? So are you able to say no for both of those?
Yes, you can, once it's sealed or expunged, you can lawfully deny it exists on that application. So you're not really lying, you're just following the state statutes and saying, no, that doesn't exist. Again, healthcare, security clearances, childcare, DCF, that kind of stuff, you still have to disclose. But for the most part, those other 98% of employers, you can just check that box, no.
Okay, awesome. Now, what about when you were saying it takes about 6 months for the process to be complete? Once you get everything back from the FDLE, you have to go to court. Is that true? And
Yes.
What does that process look like?
So a hearing is only required if the state is going to object. And by statute, there's very limited reasons that they can object to these. So I would say in about 90% of cases, there will be no court hearing. If the state objects, so there's a party objecting to the actual petition, then there'll have to be a hearing in front of the judge, and the judge makes that decision. It's discretionary with the court.
Okay.
But for the most part, we just send, once the state files their position, so once all the documents come back from the Florida Department of Law Enforcement, they're going to give you a document called a Certificate of Eligibility. And it's basically saying you qualify. And that document has to be filed with the court along with the affidavit and the petition. And then you have to send a proposed order to the court's chambers with a copy of the state attorney's office. The state attorney will give their position. They'll file it with the court saying, normally, 90% of the time, no position. We're not taking any position. We're not objecting. And then the judge could just sign it in chambers, and they usually do.
So if the state is not objecting for the 90% of those folks, and you send the proposed order to the judge, then the client would not have to attend a court hearing?
Correct. Most of my clients never have to go to a hearing. I do dozens of these each year. I think I've had 4 or 5 hearings over the past 25 years, so it's very rare.
Oh, it's very limited. Okay,
Yeah,
so
to have a
that's
hearing.
reassuring for someone.
Yes, so that as long as they got all their paperwork done, and again, it has to be very specific. It has to comply with those Florida statutes. There are examples of that. Some clerks' offices, clerks' websites will have examples of the orders for sealing and expunction that will qualify in their jurisdiction. So like Seminole County, Orange County, they might be slightly different, but you can download those off the website as well.
And that specifically would be what you could use to then send to the judge before he or she is then signing off on everything.
Yes. Now, I do get a lot of cases where they're in the middle of the process and they get stuck, because it is a process. And where they usually get stuck is after they get that certificate of eligibility and they have to file court paperwork. Because then you have to file a very specific petition, a very specific affidavit, and all of that has to be done with the certificate FDLE gave you. So that's where people get into a little bit of a trouble and they get bogged down in those details.
Okay, now for people that may not be familiar with some of these terms, what is the difference between an affidavit and a petition?
Right, so an affidavit is a sworn document as opposed to an unsworn document. Sworn meaning I swear to tell the truth on this document. It's usually notarized, and it usually has a little box down there saying I'm swearing or affirming this is correct and true.
Okay, gotcha.
A petition is just basically saying, hey, I would like the court to seal or expunge this, and this is why.
So you're requesting the court to take some action.
Correct. And the affidavit is basically saying, I qualify. I haven't been convicted of any charges. This case was either dismissed or withhold of adjudication, basically stating I qualify and swearing that that's true, that I qualify.
Perfect, and you're submitting all of that together.
Correct. It's one big packet, goes to the court, it gets filed, state attorney usually responds within about 30 days on average, depending on the state attorney's office. So again, that's within that kind of boxed in 6-month period that I was talking about. And then when they file their position, hopefully a no position or a non-objection, then the judge can just sign it in chambers. It doesn't end there, unfortunately.
It doesn't end there, but it's almost close to the finish line.
So close.
Okay.
That's the court process. So the court process is beginning to end is the application all the way to the court's order. And that's about a 6-month process. After that, the clerk, after you pay the court costs, the clerk is going to send certified orders to the Florida Department of Law Enforcement from the judge and to the law enforcement agencies that were responsible for the case, like the local city police department or the sheriff's office. And then those agencies have to remove the information. So they're ordered to remove it. FDLE removes it. FDLE sends a letter saying, I've complied. For some reason, the other agencies never sent such a letter, so you have to hope they complied.
Right, you're keeping your fingers crossed that they've done the same thing.
Yes, fingers crossed, and usually they do. I have had a couple cases where, several months later, it still showed up, and I called the actual agency, and it was kind of at the bottom of the stack, and they had kind of left it there and forgotten about it. But for the most part, they're pretty good about doing that. It takes about another 60 days, on average, in my experience, for that to really not show up again. So there's a 6-month period, and there's 2 months for them to comply with the court's order. So in essence, it's really 8 months.
So nearly a year from start to finish, you want to give yourself to make sure you're taking care of all steps, making sure the paperwork is documented, submitted correctly, and then having that leeway just in case something gets returned to you.
Absolutely. And remember, some employers do periodic background checks, like a once a year or once every 2 or 3 years. So they need to check with their employer as well, because they might have a good job, but then that's going to be showing up later when they do a periodic check. And they want to make sure they give themselves ample time to get this done before that background check happens.
Wow, okay. So how can legal aid help individuals that are eligible with pursuing a record getting sealed or expunged?
Well, legal aid generally will ask the right questions, right? Like, are you eligible? And we'll ask all this series of questions to make sure that they're not just wasting their time or money doing this, because they're going to be eligible, hopefully. We can never know for sure until the background check comes in, but that vetting process is really important. Legal aid will set them up with a local attorney, like myself, that works and takes on legal aid cases, that will help them through the process, get all the paperwork to them, make sure it's all done correctly, file everything with the court, and get it all done.
Okay, and when they're doing that, like you said, for the most part, the client's not having to go before the judge in person to court. You're handling all that on their behalf.
Yes, the biggest thing is getting the paperwork back, right? Because it's, I can't sign for them and I can't roll their fingerprints. So those two things I cannot do.
So that's their homework to take care of.
And the homework is a big deal because until that's done, I can't begin.
Okay.
So once I get them the paperwork, getting it back to their attorney timely is very important. And, you know, I keep after them every couple of weeks. Hey,
Check-in, status updates.
right, have you
see
got
how
that
they're
done?
doing.
Right, and you know, we talk about like, you know, where do I get it notarized, and how, you know, who's doing prints, and where can I get that done? So those kind of things are, you know, just logistical, but you know, it's also helpful to talk to the attorney about that too.
Okay, and what are some mistakes that you see people can maybe avoid before even starting the process?
Well, I would say the most common mistake is forgetting about that case they had 20 years ago in Georgia, you know, where they're not going to be eligible. That's the most common mistake. You know, I think another mistake is not getting their signatures properly notarized. Some people think they can sign it and then go to a notary, and the notary will just sign it for them.
Oh, but you can't. You have to be able to go with the paperwork that's
Yes.
blank and then sign in the presence of the notary.
Correct. And so they sign it and they take it to the notary, and the notary says, I can't do this, you already signed it. So we have to kind of start over from there. Very common mistake. If they're doing the paperwork themselves, another common mistake is just writing out motions that they found online. ChatGPT, AI, it's a very useful tool, but you really want to run that by an attorney before you file it.
Okay, well, we are so grateful to have you here with us today. Thank you so much for your time, for your insight, your wisdom and knowledge, and I'm so thankful to you for being an attorney on legal aid that can help people to pursue this process.
It's a pleasure, thank you.
A criminal record can have lasting consequences, but for those who qualify, sealing or expungement may provide a path toward new opportunities. Thank you for joining us, and thank you for watching. I'm Charlene Stanford Green, and this is The Domino Effect.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty.
At the Legal Aid Society of the Orange County Bar Association, we know that access to justice can change lives. For more than 60 years, we've been proud to stand beside our community by providing high-quality legal services to those who need them most. If you need legal help or you would like to support our mission, visit legalaidocba.org or call 407-841-8310 to learn more. Thank you for watching The Domino Effect. And remember, perpetual goodness goes a long way. Until next time.